Hi everyone and welcome to Legal Aid Queensland's webinar on youth justice. Today we're going to do a bit of a Q&A session. I've got David Lawler here with me. He's a lawyer in the youth justice team and he'll be running through the presentation and then he'll be available for questions afterwards as well. So I'd just like to make you aware that this webinar is for community legal education purposes only. And I'd like to begin by just paying my respects to the traditional owners of the land on which we meet today, paying our respects to elders past, present and emerging. I'm going to go over a few housekeeping slides. So today's webinar will be recorded. It'll be published on our information for community workers and carers page, which many of you are familiar with on our website. And if you are having any technical issues, the number to call is on the screen there, 1-800-136-402. Okay, so most of you should be logged in with mic and speakers. If you'd like to go ahead and download the handout now, that's just in the handout section of your toolbar. And as we said earlier, there'll be a small presentation, but this session is mainly to answer any questions you guys have. So as you think of them, please just type them into the questions box. We probably won't get them to them until after the presentation, but it'd be great to have them there waiting when we're ready. All right, we're going to start off with a quick poll. So we're just interested to know, what area do you work in? Are you from South East Queensland, far north Queensland, regional, or from outside of Queensland today? We've got many of you from South East Queensland and a few from far north Queensland. Haven't got anyone from outside of Queensland at this stage. I've got a few of you from regional Queensland today as well. I'll just close that off and I'll share the results for you if you're interested to see the other audience members today. All right, and one more poll. How would you rate your knowledge of Legal Aid Queensland? Do you know a lot about us, have some knowledge, or have not heard of Legal Aid before maybe? It's been a really good mix. A lot of you with high, good and limited knowledge of Legal Aid, and I'm sure you'll learn a lot more about us today as well and how we can help you with youth justice. Just share that with you now. All right, I'm going to pass you over to David now. We'll run through the presentation, and as I said, if you have questions that come up along the way, please type them into the questions box. Please refrain from using any clients' names. Just keep them general and useful questions that would help others. Okay, over to you, David.
All right, thanks everybody for joining us today. So what I thought we'd do is just talk a little bit today about when a child is actually charged with an offence, or what a police officer can do when a child commits an offence, I suppose. This is just really generic information so that you can assist, for those of you who work with kids and are supporting kids who are going through the criminal justice system, just give you a bit more of an idea of what actually happens and the sorts of things that the police take into account when they decide whether to charge a child or not. So you can see there from the first slide that basically a police officer has three things they can do. So if a child commits a crime, the police can take no action. They can offer the child what we call a diversionary option, and we're going to explain what all these things are. Or they can charge the child with an offence and make them go to court. Okay. Those are the three options available to them. And the three options are in something called the Youth Justice Act, which is the bit of legislation in Queensland that governs what happens to kids in terms of bail and procedure and also sentencing in Queensland. So let's talk first about diversionary options. So what I mean by that is that the Youth Justice Act talks about, well, basically has a preference for children to not be charged with offences if at all possible. Basically, we know from data and research that children who come into contact with the police, often that's just simply enough for them to get the message and to not offend again. So the Youth Justice Act talks about a number of ways in which that can occur. the first thing they can do is they can caution a child. Now, a caution is a particular process that the police go through, which is quite a formal process. It requires a child to basically admit the offence, and then the police will formally caution them and even give the child something called a notice of caution. If it's a little bit more serious than that, or if the child's been cautioned in the past, or if there's a victim involved, then the police might think about referring the child to a restorative justice process, and that's what we used to call conferencing. So the restorative justice process is usually a conference, but it can also be other things, such as basically a program run by Youth Justice to assist the child in understanding the consequences of their actions. The police also have the option to refer a child to a drug diversion session, much in the same way that they can do for adults, and that's without having to charge the child with an offence. And they can also, if it's in a graffiti type offence, they can refer them to a graffiti removal program, and that's also quite a good idea, because it means that, again, the child doesn't get charged with an offence, and it's simply they do a bit of graffiti removal, almost sort of like some volunteer work to make amends for their crime. It's a common misunderstanding with the youth justice system that even if a charge does go through court for a child, that at the end of that they don't have a criminal history. That's not true. Children who are charged with offences and are given an outcome in court, or a sentencing outcome in court, have a criminal history. Now, that criminal history, there are some limitations on how it can be used. So, for instance, ordinarily in the youth justice system, they don't record convictions against children. So if the child, when they turn into an adult offence, that criminal history can't be used against them. It can be used for a variety of other purposes. So, for instance, it is the case that if an adult who applies for a blue card, for instance, has a juvenile criminal history, then that has to be disclosed. It's also if somebody is seeking admission to be a lawyer or another professional body, depending on the legislation involved, that has to be disclosed, even though no conviction was recorded against them. So even though it says that a children's criminal history can't be used against you, there's about 1 million exceptions to that general rule. All right, we'll go to the next slide. So when the police are considering a diversionary option, what sort of things do they have to take into account? The Youth Justice Act makes it pretty clear. So the first thing the police look at is they look and see whether there's been previous diversions given to that particular child. And they also have a look at their criminal history as well. So, for instance, if a child has been diverted before, they've been cautioned, or they've gone through restorative justice processes, and they're just not getting it, that doesn't seem to be having much of an effect, then the police will more than likely charge the child in those circumstances, because they've pretty much exhausted all those diversionary options. They'll also have a look at the circumstances of the offence itself. So the more serious the offence, the more likely it is to go through court, although we do see different types of offences being diverted. And there's also a rule that says a police officer must delay starting proceedings to assess everything appropriately. So they don't have to make a decision about whether to divert a child straight away, even though that's often the case, that police will make that decision immediately. In fact, they should do that. They should maybe talk to the parents and have a good think about things, maybe approach the victim if there's a victim, and see if they're willing to participate in a conference with the child, and then they can assess what to do from there. All right. Oh, Catherine's got a poll here.
Okay. So we're just interested to know what you think about this statement. Is it a true statement or a false statement? A diversionary option must be considered before a police officer charges a child with an offence. So your answers are going pretty 50-50 right now. Keep that on for a few more seconds and let everyone's votes come through. All right. So, David, is that true or false?
It's true.
There you go.
So the Act makes it very clear that police must consider a diversionary option before they charge a child with an offence. Now, it doesn't say how long they have to think about that for, of course. Sometimes it's self-evident. So if it's a child that's really well known to the police who's been through court on numerous occasions, they have to say, well, maybe I'll consider a diversionary option. No, it's not appropriate, and then we just move on from there. But they have to consider a diversionary option before they charge.
Thank you. Fun facts.
Oh, fun facts. I don't know how fun these are, but I couldn't think of a better title than this at about 5 AM when I wrote this. So, basically, offences in Queensland are split into serious and non-serious, and there's a slide on this a little bit further, and we'll chat about that in a second. So, a serious offence can be diverted. Diversion option must be considered. And in order for a diversionary option to take place, the child must admit the offence. And usually the way they do that is by participating in a record of interview with the police. The child has to also consent to the diversionary option, so they have to consent to a caution or they have to consent to participate in a conferencing process. And there's also some extra powers in the Youth Justice Act. So if the police don't do what they're supposed to do, there's nothing stopping a lawyer making an application in court for a child to ask the court to dismiss the charge and instead caution the child, because the police should have done that in the circumstances. And that's something that's used. My team of lawyers do it pretty regularly. I don't know how common it is elsewhere in the state, but certainly in the southeast corner, that application is made quite regularly and with a great deal of success. All right. Well, that's just a quick overview of the diversionary options available and a little bit of information around that. This is a situation where the police have decided to charge a child, and so what does that actually mean? Well, it means that they've been officially charged by the police with an offence. But how do they actually get before the court? Well, there's three ways. The first way is with a notice to appear, which is a piece of paper which details the court, what time they have to be there, and the offences that they have to go to court for. And they're required to give that to a parent. They're required to let Youth Justice know, and they're required to give one to the child as well. Sometimes the police will arrest the child and take them to the watch house, and then the watch house keeper releases the child on watch house bail, is what it's commonly referred to, or police bail is another term used. And the other way they can be brought is that they can be refused bail by the police and brought before the court in custody for a bail application to be made on that day. So, with a lot of kids in Queensland, bail is a huge issue. So what I can tell you is that in Queensland, there are a lot of kids currently in detention. There's well over 200 and something children in detention at the moment. And of those children that are in detention, 83% of them are on remand. So they haven't actually been sentenced. So the Youth Justice Act tries to assist with this by saying, look, a child has to be released on bail unless the Youth Justice Act itself requires them to be in custody. And this is where a little bit of confusion comes into play for courts and lawyers, is because the Bail Act that applies to adults also applies to children. So it can get a little bit confusing. It's not a particularly clear area, and I think sometimes this might be the reason why our remand rates in Queensland are a little bit too high. So the Act also says that detention should be for the shortest time possible if the child is on remand. That's in the principles of the Youth Justice Act. It's in the back of it. There's youth justice principles, and everything in the Youth Justice Act has to be read with those principles in mind. Now, people often get confused about when a child can actually be remanded in custody, and there's really only four reasons why a child can be deprived of their liberty prior to sentencing. The first is if they present an unacceptable risk of reoffending, an unacceptable risk of failing to appear in court when required, an unacceptable risk of interfering with witnesses, and or endangering anyone's safety or welfare. So that last one I split into two when I do my training around the state. So the important term there is that the risk has to be unacceptable. What the courts acknowledge is that anybody released on bail is a risk of reoffending. It's just about how that risk is managed. And if the risk can't be managed or mitigated or reduced, then the child will be in custody until that matter is dealt with. So here's a few examples of when a child can't be remanded. Okay, to teach the child a lesson. I've heard that statement in courts before. Well, perhaps if they just get remanded for a couple of weeks, they'll realise that they're doing the wrong thing. That's not a reason to remand a child in detention. For welfare reasons, and you can see that I've put an asterisk there. So if a child is struggling or maybe addicted to drugs or something along those lines, they can't simply be remanded in custody, for instance, to detox. You can't deprive somebody of their liberty just to do that. What their drug addiction might be, drug addiction might be so out of control and risk of reoffending, but that's very different to welfare reasons in terms of remanding a child in custody. The Act was changed to stop children being remanded for welfare reasons. So, for instance, a lack of accommodation is a welfare reason, and you cannot remand a child because there's nowhere for them to go. That's a matter for child safety, to find somewhere for them to go, and for those links to happen between youth justice and child safety. That's very clear. It was said by the Minister who introduced the amendments to the Youth Justice Act in 2010. However, you can see a big asterisk there as well. And the reason why that is because it's a very brave court that lets a kid out on bail, particularly a very young child, when they have nowhere to go, so essentially releasing them to be homeless and living on the streets. So there's obvious concerns by judicial officers that they don't want that to occur. A child can be, just to confuse you further, can be remanded for welfare reasons if their welfare is at risk because of the nature of the offence itself. So it's a very limited circumstance that a child can be remanded. So an example of that might be that the child comes from a remote community and they have committed a serious sexual offence against a young child within that community, and as a result of that, the community are very keen to do some harm to that child who has been charged with the offence. So it would be a risk to allow that child to return to that community. So they would be remanded in custody until more suitable accommodation could be located. A child also can't be remanded in custody simply because they breached their bail conditions. This is where some confusion exists. The Act makes it very clear that children can't be charged with breaching their bail conditions. And what I mean by that is if a child breaches their curfew, or, for instance, they don't stay at home when they're supposed to, or they don't participate in their conditional bail program, those are what we call breach of bail conditions. That's very different to not showing up in court. And the Bail Act was amended years ago to make sure that the offence of breach of bail conditions doesn't apply to children. What the court has to satisfy themselves, you can see there's an asterisk there because there's always an exception to the rule. The court considers that if a child has been given bail conditions to stop them reoffending and they've breached them, and the breach is of such egregiousness that it means that the child becomes an unacceptable risk of reoffending or an unacceptable risk of failing to appear, then they can be remanded in custody. So the breach must be serious enough to mean that the risk of those risks that were discussed in the previous slide have become unacceptable and haven't been reduced. Now my team, I'm the principal lawyer of Youth Legal Aid, and I've got 10 lawyers over there at the moment. We're in a separate building to the main Legal Aid building. And we have a remand reduction team within my team, which I'm basically it, and another lawyer. And we do bail applications to the higher court, which is the Children's Court of Queensland, all over the state, for children, whether they're in Doomadgee or whether they're in Charleville or Brisbane. And we do it on behalf of lawyers who appear for children on legal aid grants, and also for the Aboriginal and Torres Strait Islander Legal Service also, or community legal organisations will apply for bail and make those applications. So that's what I was doing before I've given this chat to you all today. I've been preparing a bail for a child from regional Queensland that'll be heard next week. Okay, so once all that bail issue has been sorted out, let's talk about how that proceeds, because this can often, in my experience, create a fair bit of confusion with community workers and parents when they're dealing with kids. Because often there's an expectation that on the first time a child is charged with an offence, you go to court and you just get dealt with. Unfortunately, that's not often the case, because you'll see that offences can be are split into two categories. There's serious offences and there's non-serious offences. That wording is a little clunky because there's some offences that are defined to be non-serious that are actually quite serious. So it's just a term of art, I suppose, in the Act. So a serious offence is an offence that has a maximum penalty of 14 years or more. So it would be things like arson, rape, armed robbery, offences of that type. Now, a burglary charge also has a maximum penalty over 14 years, but because an adult can deal with that before a magistrate, a child can too. So there's another exception to that rule within the Youth Justice Act.
All right, another poll. How often do you help someone going through the Children's Court of Queensland? So, do you never help people going through the Children's Court? Do you have them monthly, weekly, daily, perhaps? We can see there's actually quite a lot of you who never need to help people going through the Children's Court of Queensland, but we've still got a fair percentage who help them daily, weekly and monthly. So I'll just share those on the screen quickly now. Okay. Back to David.
All right. So the charges are defined as a serious one. So let's take an armed robbery charge, for instance. That charge must go to the higher court, and in Queensland, both the higher and lower court are referred to as the Children's Court within the legislation, which is wonderfully confusing for everybody. But the way we separate them is we refer to the higher court, or the district court equivalent for children, as the Children's Court of Queensland, and then the lower court, the Magistrates Court, as the Children's Court, and that seems to separate them in most people's minds. So if the charge is serious, it means that the charge has to go through a committal process, and the child will have to go through that process obviously as well. This means getting a brief of evidence, and a brief of evidence is basically all the police statements and all the exhibits, so records of interview and photo boards and DNA evidence, all those sorts of things have to be obtained by the police. So what this means is that if a child is charged with a more serious offence, a serious offence, it can take between 9 and 12 months to be finalised for a charge of that nature. And there's nothing much the lawyer or anybody else can do to sort of expedite it through that process. So for instance, a child who is charged with robbery on their first mention, for instance, a brief is ordered, that can be 6 to 8 weeks later. Depending on when that's actually received, a committal hearing might be able to occur on the next date, or if there's material still outstanding, it might have to be delayed. And then even after it's gone through a committal process, which is just simply the magistrate sending or committing the charges to a higher court, the Director of Public Prosecutions have up to 6 months to prepare an indictment. An indictment's just the word for the piece of paper with the charges on it, which is the official court document of the charges facing the child. Now, the Director of Public Prosecutions are very good. They try to do it within a month or two of committal, but it really depends on how busy they are and in which region the child is charged also. Oh, I haven't done that. The child has the election, but that should be election for all charges. What that means is that if the charge is non-serious, okay, so it can be dealt with before a magistrate, it doesn't have to go to a judge in the Children's Court of Queensland, then the child can elect where that charge is dealt with. So, for instance, if they want to, they can send it up to a judge. As a lawyer, we try to dissuade the kids from doing that because we know the sentences are a bit higher in the higher court, in the Children's Court of Queensland, and there's also quite significant delay in being dealt with. So there's no reason really for the child to elect to go to the higher court ever, quite frankly. Sometimes they will if there's already serious charges before the Children's Court of Queensland and you want to have the child dealt with for all the charges together. But if they're just standalone charges, I think they should be dealt with before a magistrate. So by either pleading guilty or pleading not guilty and having a trial before a magistrate. Okay, this is just a quick slide on sentencing. So sentencing for children is a little bit different to adults. So there's some very common terms, things that like community service, like probation. There's something called a conditional release order, which is a detention order that's served in the community. And the way it's served in the community is not through home arrest or anything like that. It's by conducting a 3-month intensive program with youth justice, and that's called a conditional release order. So, for instance, a child can be sentenced to 12 months detention, but if they do this 3-month program, then the detention goes away. That doesn't hang over their heads anymore. It's very important to remember that sentences shouldn't be imposed for welfare reasons against children. Sentence should be imposed because of the nature of the offence and to maximise the child's ability to rehabilitate, whether that's in the community or in a detention centre. Detention is the last resort, of course, so most courts will attempt to try a number of community-based options before they start thinking about detention. And in fact, there's a recent decision that's come from the Court of Appeal that reiterates that approach. And sentencing is really there to promote the rehabilitation of the child. So sometimes in court, you'll hear things said such as, oh, look, this child is smoking some drugs at the moment. I think they would be assisted by probation. Well, that's not a proper way of sentencing a child. Basically, the charge must be of such seriousness that probation is the appropriate penalty. Because we know, with many of you working in community organisations, that there are community organisations or health organisations that children can be referred to and their parents can get referred to give some assistance from the child without putting them on a formal youth justice order. So lawyers do have to be a bit careful about that, but I'm sure that if you have been to court with a child, you've seen that being said before. All right. Another question we get from community workers is legal advice. When should a child get legal advice? I think the basic rule is that before any contact with the police, the child should probably chat to a lawyer. I've given our number here. That's the 1300 65 1188 number. That is, go through our call centre and then they refer the calls to a team of specialist youth lawyers here. I noticed the Attorney General announced a specific after-hours advice line to children who are charged with youth justice matters. I can advise that that's a work in progress at the moment. The logistics are just being sorted out about how that's going to work. but that should be something that's running in the next month or two. And when that does, we'll certainly advise everybody that that exists and give everybody the number for that advice line. There'll be a launch and some promotion of that advice line when it occurs. Now, we take a very different approach to some lawyers and some other organisations in that a child has the right of silence, just as an adult has, and there are some legal organisations who will tell a child not to give an interview to police. That is not our approach, because as you've seen, if you can remember when we first started this session, if a child doesn't admit to the offence with police, then a diversionary option isn't really on the table. So what we do is we ask some questions of the child about whether they committed the offence. All that is covered by legal professional privilege, and then we talk to the police officer, the arresting officer involved, and say, look, is this something that you're considering a diversion? Is this an appropriate matter for diversion? And if it is, then we can go back to the child and say, look, you know, if you do admit to the offence, then you're just going to be diverted away from the system. If you don't, it's likely that, you know, the police will charge you with an offence, and it's a matter for you. They may not charge with an offence, but at least we'll give some more appropriate advice about the circumstances and what the child should do in those circumstances. It's really important to remember that children do not have to participate in a record of interview with police if they don't want to. It's also inappropriate, and we see this a fair bit, that if the offence has occurred against a particular person, so for instance a common assault or willful damage, particularly maybe in a care placement, it's not appropriate to have the complainant being that worker giving that child support in a record of interview. Unfortunately, that a fair bit, and what it does in fact do is it means that the record of interview is inadmissible because the support person wasn't appropriate. Before a record of interview is admissible against a child, there has to be appropriate safeguards met, which includes a support person and making sure that the child gets advice and information before they participate in that interview. Okay, so here's all of our office locations. The Youth Legal Aid team is based in Brisbane. There's 10 lawyers, soon to be 11 or 12 in Brisbane. We also have dedicated youth lawyers in Cairns, Townsville and Mount Isa also. And there's our contact numbers. And as I said before, once we get the advice line up and running, there'll be a dedicated separate number for the advice line. Okay, has anybody got any questions?
We've got one question here that's come through from Catherine. So Catherine's wondering, can diversionary options be applied for youth under the Domestic Violence Act for breaches to a domestic violence order?
Yes. I don't think there's anything stopping that from occurring. I'd have to have a really closer look at the domestic violence legislation, but there's certainly nothing in the Youth Justice Act that says that that can't occur. We don't see too many children coming through court with breaches of domestic violence orders, although it is becoming a little more common. And I think because it's a court order, police may not think that it's an appropriate option in the circumstances. One of the things they can do as far as diversionary option goes for breaches of domestic violence orders is, for instance, organising a restorative justice process. Now that doesn't mean that they have to have a conference with the victim, because that wouldn't make any sense. But what they can do is Youth Justice can run an anger management course as part of a restorative justice process to assist that child and do some cognitive behaviour therapy with that child also through Youth Justice without them having to be on an order. But I think given the prevalence of domestic violence in the community and the community expectations in regard to domestic violence now, I'm a little reluctant to think of those sorts of options for those sorts of offences. I should add that I'm going to check the Domestic Violence Act when I get back to my desk, and if that's incorrect, then we'll send an email to the participants today and just update them. But if you don't get an email, then what I've said so far is correct.
Thanks, David. Just a reminder to submit your questions through the questions toolbar. We've got Q&A for the rest of the session now, so this is a great opportunity for you to have those answered by David. Is there anything that you think would be important if we can just give the audience a few tips to take away from today's session?
If you're supporting a child that has contact with the police, I think one of the most important things is to make sure that they get access to a lawyer through either legal advice or if they have a pre-existing lawyer, make sure there's contact with that lawyer, because there is some confusion that the lawyers are told by police when a current client is charged with new offences. That hasn't happened in my 22 years of practice, and I don't think it's going to start now. So we're often completely in the dark until we get a contact from either the child, their parent, or somebody supporting that child to say, oh, were you aware that the child's in custody, for instance? Because we're not told that they're in custody. We have to get that information from others. So it's very important not to make an assumption that the lawyer is aware of what is going on because without somebody telling us, we're completely in the dark. There's not an automatic referral process.
Thanks, David. When it comes to police interviews, who can sit in on the interview with the child?
Basically, the best person to sit in with a child is a parent or guardian, or somebody that the child feels comfortable with. It doesn't need to be a parent. So, for instance, if the child's relationship with their parent is a bit ordinary, then that's not an appropriate support person to have in the room. In some jurisdictions, they seem to weigh heavily on justices of the peace to become support people. I know in one jurisdiction that was very, very common. Where I think there was a justice of the peace who had sat in on some 365 interviews, I remember, when I cross-examined him. And the information that was given to the children was just to make admissions to the offences. So that wasn't getting the support or the information that the child needed. And so there was a problem with records of interviews that occurred. There's also some cases that occurred in western, sort of northwestern Queensland, where a liaison officer with the police, Indigenous liaison officer with the police, was called in to sit in on the interviews, but that person was perceived by the children to be a police officer for all intents and purposes, or a person of some authority in the community. So that wasn't appropriate in the circumstances either, because the child didn't feel comfortable talking to that person or getting the appropriate advice. There was obviously a pretty incredible conflict of interest there. You can see another question there. Can the support person be the youth worker or case manager? Look, I don't think that's a good idea, because essentially, if you're a support person, you're becoming a witness in the matter. So what that means is that if there is an allegation that the child didn't understand what was occurring, you could be cross-examined by the lawyer as to what you told that child, what support was given at the time, what the child told you. You can become a witness. And I think, quite frankly, within youth justice, if you do work for youth justice, there would be policies in place that's not appropriate in the circumstances. So you just have to be well aware of that you can become a witness in the matter of your support. If you're a youth worker from a community organisation who supports the child, there's no issues with you. If the child picks you to come and be a support person, there's no issues with that at all. If you work for youth justice, then no, that wouldn't be appropriate. I don't think.
Okay, thanks. Just while we've got the questions still rolling through, I'll just let you know on the screen now you can see our information for community workers and carers page. That's a great page for you. It's got some more information that would be helpful there. And then we also have information on our website about youth justice, and we've got fact sheets and guides that you may like to check out as well. So has anyone else got any more questions? Just while we wait for them to come through, David, are there any more key points that we should be going over today?
Look, no. I think that's the real basics of supporting a child through the process in terms of understanding the whole process. From a lawyer's point of view, I suppose it's also important when dealing with lawyers, if you're a community worker, is that we have a different confidentiality rules often than what community organisations have. So I had I'll give you an example. I had an interesting chat with child safety, where somebody from child safety rang inquiring about some information about a particular child, and I couldn't provide that information because I have legal professional privilege with my client. So my client is entitled to the same confidentiality and privilege in what they tell me as if that child was an adult. Now that can become a bit difficult when we're dealing with parents, because there have been examples where the child has said, I'm not giving you permission to speak to my mum or dad about this, and we have to respect that. That is part of the solicitor's rules, and it's part of our legislation in legal aid also. So to give information in circumstances where you do not have permission to do so, or a specific authority from the child, we are actually acting unethically or not acting in the child's best interest as far as our rules are concerned. So I know sometimes that can seem a little bit weird, but before we talk to anybody, whether you're a youth worker or case manager or a support person, we really need the authority from the child to have those conversations with you. Also feel free to ask any other questions you want about youth justice. So it doesn't have to be particularly on this topic. But if there's anything else that's you're thinking about, so for instance the 17-year-old transition, I know people are probably quite keen to know about. Look, we don't know much yet. All we do know is that the date has been pushed out till February next year, just as they sort out their regulations in youth justice. So a lot of regulations and maybe a little bit of legislation have to be drafted just to ensure that the 17-year-olds who are currently part of the adult system flow through to the youth system and how that's managed. So I know that work is ongoing at the moment. So what we plan to do is that when that occurs in February, I think it's February the 15th from recollection, don't quote me on that though, we'll do another of these sessions at the end of February where we'll explain what the transition means to 17-year-olds. We'll also talk a bit more about the advice line when that's up and running.
We've had another question, David, just about youth justice conference. Someone's wondering, how long does a conference normally take?
It shouldn't take any more than 4 hours, but conferencing, for a conference itself, anything more than 4 hours is a bit silly. Usually the average is about 2 hours. But what conferencing can include, so for instance, when there's a sexual offence, the conferencing process can actually be, also the restorative justice process, not the conferencing process, can up to 12 months. Because often what police will do when they're diverting is they will engage youth justice, engage a offenders programs, say through university, for instance, the experiment they have down there, to provide some counselling and some interventions for that particular child as part of a restorative justice process. So there's not going to be a conference with the victim in those cases, obviously, but it's a way of getting that assistance to the child, getting that cognitive behaviour therapy that would have occurred anyway, had they gone through court. But it will depend on what sort of sense it is, within the family. Then they often look at those sorts of options. But if it is a sexual offence against a stranger, or it's a more serious sexual offence such as rape, then those matters would more than usually go to court because of the expectations of the community and certainly the police view about the seriousness of the charges. So it really depends what sort of restorative justice process is occurring, but we have seen some quite lengthy processes.
What are some of the other results that can come out of conferencing? Could the child agree to an apology or community service or anything like that?
Yeah, they can do. They can. An apology is usually a stock standard result. They can also do things such as make agreements with the victim that they'll start attending school again, or they'll get some help for the issues they have, and youth justice can help them with that. They can also do some community work, but that has to be dealt with quite sensitively, because we obviously don't want kids just rocking up to a strange adult's place and washing their car, for instance. That's not appropriate, so they want to have some supervision over that. The PCYC sometimes help with that. So those are often what occurs. The satisfaction rate with conferencing is huge. I think something like 90, last time I saw stats, it was 97% of victims thought it was a really worthwhile process going through. It's quite a significant tough on crime measure. Having a situation where the child must meet their victims, I think, is quite powerful. I've attended a lot of conferences, and good results can occur. They do work. For some kids, they're not going to work. They're just those kids that aren't going to care. But at least it's worth giving a try to, I think.
Just on that note, Sally's just asked, how often is the victim involved in the conferencing process?
Well, the new legislation allows for a victim or a victim's representative to appear. I think it really depends on the offence. If the offence is, for instance, burning down a train station or something, or damaging a train station, often it'll be the police officer there. They're not going to bring the Minister of Transport along to the conference to explain the damage. So it really depends on the nature of the offence. Sometimes a victim will not feel comfortable attending the conference. And in some cases, if it is an appropriate case, which I think is not often, to be honest with you, then they can have a victim's representative there coming along to explain it. So, for instance, for an arson offence, they might have somebody from the fire brigade there to explain how things could have got out of hand. There has to be a conference where it's referred by the court. So the court has the option of referring this to conferences as well, but it really does have to be, they can refer to restorative justice, but it really has to be a conference. When the police make a referral, the victim can be involved if they want to, but if they don't want to, it doesn't mean that the process fails. It means that there can be an alternative restorative justice program. So things like counselling and cognitive behaviour therapy that can work with a child about.
Thanks, David. We have another question. So Linda's just wondering, does the Legal Aid Youth team provide any advice during school each week?
We do. And when the advice line comes on board, I think we might have to roster some more staff on. The big issues there, we won't give advice about people losing their rental bonds and being tossed out of their accommodation by angry managers. We used to do that, but when we had a youth advocate, but those days have since passed. So it will purely be around criminal offences. The key messages for school leaders is keep your hands to yourself. I think is a good one, because there's obviously a lot of drinking that occurs with the young people, and some shenanigans that are a result of that. Give a lot of advice to kids around police talking to children about sending appropriate selfies of their naked bodies, and kids don't realise that that's a incredibly serious offence. It's actually an offence of producing child pornography, and if you send it to somebody, so if a boy takes a picture of his genitals and sends it to a girl that he's interested in, he's then also distributing pornography. And if the girl gets it and then doesn't delete it straight away, she can be done for possessing child pornography. So kids don't often understand how serious matters are, particularly when there's alcohol on board. And they do those really high risk-taking behaviours. And there's actually an offence of taking part in high-risk behaviours that we see coming through the Southport Children's Court during Schoolies Week a fair bit. So I think it's that. It's also understanding consent. Also, I think we see a little bit of that occurring, and also kids having too much alcohol on board and then getting into fights. Those seem to be the main sorts of offences that we see, and stealing things from. If you take something from a unit and then leave it on the beach and not caring about bringing it back, then that's obviously can be considered to be a stealing offence in some circumstances.
I've had another question about what age do you need or can you be able to be charged with a criminal offence? What's the minimum age for a child?
10.
10. Okay.
10.
Is there any extra support, David, for children with a disability going through the court system or when they're having interviews with police or anything like that?
There should be, but I think it depends where the child is. If they're in Brisbane, I think it's much more likely. But I think as soon as you get out into Western Queensland, where those support services diminish somewhat, things become a little bit more problematic. Certainly, if a child has an intellectual disability and has been referred to a conference, youth justice are wonderful in getting some extra supports around that to make the conference occur. And sometimes a victim understanding that the child has a brain injury or has a level of disability can also assist the victim in understanding why the offence was committed.
Another question here from Joel. So just going back to police interviews, when a child has allegedly committed an offence and they're taken to a police station for questioning, are the police able to question and interview the child without a support person present?
Mm-hmm. The answer is no. Well, I suppose the answer is yes, they can, but the interview wouldn't be admissible. So that's the first part of your question. So without a support person, anything a child says to a police officer is what lawyers call prima facie inadmissible. So, the court would not be relying upon or allowing that evidence to go before a court. So when we interview children and they're giving interviews, the lawyers should ask a lot of questions about the police conduct and why they gave an interview in the circumstances, and let the child tell their story without giving leading questions. Unfortunately, the circumstances you've given there too, for the second part of your question, the police have arrested her and said that she has to give an interview. Well, without a support person there, the interview is inadmissible. But what I have seen is they've said to the child, you have to give an interview, and the child sits in the room and all of a sudden a local JP is brought in to sit next to the child during that interview. It is incredibly important that the child knows that they can call the police, that they can call somebody like Legal Aid Queensland. I think this advice line will be of great assistance to this issue. And look, a lot of the feedback I've got from police when talking about the possibility of an advice line is that they're very keen for that to occur as well, so the kids can get the advice and they'll know whether the kid wants to give an interview or not. But there's a lot of questions lawyers have to ask around the interview process. Just because the police do an interview without a support person, it doesn't mean that it can be used against the child later. And in fact, we run trials very regularly on that basis. But police are pretty good with getting support people there.
What if, David, the child doesn't want their parents to be notified that they've been taken to a police station for an interview?
Well, usually the police don't have a duty of confidentiality to that child, so the police will still contact the parent and should contact the parent. But the child is quite entitled not to have a parent there during the interview as their support person if they choose somebody else to be their support person. But the police officer has to be of the opinion that the support person is appropriate in the circumstances. So, you know, we've had circumstances where a child has asked for their friend's mum to be the support person, but the police are aware that that friend's mum is a local drug dealer, and that's probably not the appropriate person to have there. So the child gets to pick who their support person is. It's in the police powers regulations who can be a support person. But it's really, can I just say this too, Joel? The question you've asked is a really pertinent, important question. If you are a support worker and the child has told you that information, please make sure that you come with that child to court or write something for the court for the child to give to the lawyer. Because often when we're speaking to the child, because you'd have a longer relationship with the child than the duty lawyer would, and if the duty lawyer is having a busy day and may neglect to ask that question, having that information with the lawyer is just so vitally important. So making sure that the lawyer is aware of that and that there is a problem with the interview. And if the interview is the only evidence against that child, then quite frankly, it should probably be a trial if the child wants to go down that path. In terms of legal aid will fund trials for children in the lower court. There should be no reason why legal aid is refused if a child wants to contest an offence. It's very different for adults. So if there is a lawyer who says, I can't get legal aid for this offence, maybe you want to give me a call on that 1300 number so that I can have a look at it. Because I have heard that before, and I don't think that's necessarily true. For really minor offences like evade fares, legal aid may not fund a trial, but for pretty much everything else, legal aid will.
And we've got another question just about duty lawyers, David. So if someone hasn't been able to be funded by Legal Aid Queensland, can they still access a legal aid duty lawyer if they're there and available at the time?
Yes. Kids are different. Every child, as long as they don't earn too much money, can get a grant of aid. So the grant of aid is not dependent on how much their parents earn. I think I was told 22 years ago, if James Packer got in trouble and wanted, when he was a child and wanted a legal aid to help him, there would be no issues with that. So the parent's income doesn't come into that at all. It's based on the child's income. So that may become more problematic when the 17-year-olds join our system finally, and some of them are tradies and they're earning good money. They may not be able to get a lawyer, but they would still be able to access the duty lawyer service.
Thanks, David. Well, I think that's all we have time for today, but just want to say thank you to David for answering all of our great questions and for the great presentation. I'm sure everyone would have learned a lot more about how Legal Aid's Youth Justice team can help. If you do think of any other questions, you're welcome to email us. The email is webinars@legalaid.qld.gov.au, and we can do our best to get to those as well. But thank you for joining us today. Our next webinar is on child protection, so please keep an eye out on our information for community workers page as well.
Thanks everybody.
Everyone.